Hello, everybody. It's Jeff Jenkins and Eric Clayman here again for our Thursday afternoon at 2 p.m. live Facebook presentation. Today, we're going to be talking about tips for small businesses who are having financial difficulties. Now, Eric and I talk a lot about the effects of COVID-19 and what different businesses must be going through. And certainly many small businesses, restaurants, small retail stores, things like that have really been devastated throughout the time that this pandemic's been running around. And we wanted to try to talk about the money aspect of if you're having problems with a business financially, give you some tips about things you could do. And this particular subject, I mean, we could sit here for 2 days and talk about it. So this is going to be kind of a broad brush sort of thing. Now, the bankruptcy code was altered a little bit in February of this year, February of 2020. And there was an act passed called the Small Business Reorganization Act. And that created a new kind of bankruptcy, really, a hybrid between a Chapter 11 and a Chapter 13. And it's for small businesses. The law, what was passed said your debt threshold was $2.7 million. In other words, with secured debt and unsecured debt, you couldn't owe more than $2.7 million. That was changed by the CARES Act, the COVID legislation, to be $7.5 million. But that increased amount would just last for 1 year. And the act took effect in February of 2020. So you've got 1 year from then to utilize the higher amount. And Eric and I, in looking at this new kind of bankruptcy, it's probably more Chapter 11 than it is Chapter 13. I mean, it really is. You can have a creditors committee, a secured creditors committee in this case, but it's simpler than a Chapter 11 too, and it's something that if you're having problems with your business and you go to talk to a bankruptcy attorney, let's say, it's something that you should talk about. I mean, we have a lot of people who call us and they have a small business and they think they know what they need, and maybe sometimes they're right. But most of the time, they don't understand the different kinds of bankruptcy. So they're telling us, well, I want to file a Chapter 11, or I want to do a Chapter 7 for my business, or whatever. And we're going to talk about that a little bit. But if a business wants to continue operating, certainly one of the things that we would talk to you about would be doing this new type of bankruptcy. It's like Section 5 of Chapter 11. It's like I was saying, it's really more like a Chapter 11, and one of the advantages would be that it's going to cost you a little bit less in terms of attorney's fees. It's there's not as many things that the attorney has to do as he would in a Chapter 11, but there's an awful lot, and I would think, and we've seen some estimates from other attorneys, probably $15,000 to $20,000 is what this would cost fee-wise.
Right.
So
when you say, Jeff, when you say it's less in fees, this again is looking at it from the lens of a Chapter 11, where the fees can be hundreds of thousands or millions of dollars.
That's exactly right. I mean, well, for a small business around here, if you're going to do a Chapter 11, fees are going to be more than $15,000 or $20,000, most certainly. But if you compare that with a Chapter 13, it's a lot more than what a Chapter 13 would cost, especially up front. There's
the filing fee difference in and of itself is something that you'd have to pay. And we at Jenkins and Clayman for the last 30 years have filed more Chapter 13s in the bottom 2/3 of New Jersey than any other law firm. And Chapter 13 is a type of reorganization, just like the Chapter 11 or this new Chapter 11, but it's a lot less expensive. There's only one trustee and there's no committees, as Jeff said. So why would you want to file a Chapter 13, which is the type of bankruptcy we do if you own a small business? And Jeff, we have a lot of clients, a lot of hairdressers, nail technicians. They own these businesses, restaurants, antique shops, things like that come to see us. They think they have to do a very expensive Chapter 11. Even the new kind is still expensive. But we can do a Chapter 13 and help them, right?
We sure can, assuming that they personally want to do the bankruptcy. And we're going to talk about that during this program today, about whether the business should do a bankruptcy or you should do one personally. A Chapter 13 is only for a person. A corporation can't do a Chapter 13. A partnership can't do a Chapter 13. But a Chapter 11, including this new kind of Chapter 11, a person, a partnership, or a corporation can file the bankruptcy and be the debtor. And that would be an advantage and a difference between that and doing a Chapter 13, certainly. But and just there are many differences between this small business reorganization and a normal Chapter 11. We're not going to get into those today because Eric and I would find them very interesting, but I don't think you would, unless you read bankruptcy texts at night, and stuff like that. So that's about all we're gonna spend, I think, on that particular,
Right.
just to advise you that it's there. You can talk to an attorney about it. If you have financial problems, it's certainly one of the things that should be looked at. But Eric, most of the time when we get somebody in and they're having a problem with a business, many times they don't want to continue it so much. They might want to let it die. They might want to stop it. And in those situations, what do we usually advise?
Jeff, and we see that a lot. For instance, in trades, we see an electrician who might have had one employee or a plumber who might have had one employee. And you know what? They're hearing the union's hiring and they see how hard it's been for them to run their own business.
Mm-hmm.
They have a lot of bills and they come and see us and they say, Eric, in another month, I can make good money with the union. But right now I can't pay my bills. What should I do? And there's a couple of levels when you're speaking to an attorney, even before we get into the bankruptcy aspect. First, we have to understand the assets of it. Well, we have to understand the business structure. Is it a sole proprietorship or is it a corporation now, or even an LLC type of a corporation? Remember, Jeff's question is, if the people don't want to continue in business, if they don't, then we really don't care what happens to that corporation. We tell them to speak to their accountant and do the necessary paperwork to have it closed with the state of New Jersey, so you don't have to pay continue the filing and things like that. But you just get rid of the corporation. And anyone wants to sue the corporation, there's nothing there. But we have to take care of you, and that's our job. And that's why we file an individual bankruptcy under either Chapter 7 or Chapter 13 of the Bankruptcy Code. Remember, under any section of the Bankruptcy Code, the moment you file bankruptcy, you're protected from all collection actions. What a relief our clients tell us that there's no more phone calls, letters, threats, lawsuits, utility shutoffs, anything like that is stopped. And the goal at the end is to obtain what's called a discharge, which means you don't owe anyone any more money, even though you don't pay them back or don't have to. Now, where we were going with this also was, what if there are, so we understand the business structure that you were in when you came to see us. But what if there's bills out there and there's a little money left in the pot, Jeff? There has to be certain people which you should or you have to pay, and certain people that are, and again, this is just a Facebook presentation, not a substitute for legal advice, which you could obtain by contacting us. But generally, there are priorities in who you want to pay back if you have a little bit of money in the bank, right?
Exactly. And when we do have a client come in who may want to do what Eric is suggesting, we have to, because there's a business, it takes us more time to understand exactly what's going on. And it's important to do that because there could be lenders out there who have liens on things, like money could have been lent to improve a property so they could have a restaurant. What type of lien does the lender have? The landlord might have a lien on rents. There may be a lien on all the equipment that's not attached to the walls in the business. Um, there's vehicles, there's uh, accounts receivable, all kinds of stuff. And we need to understand exactly what the posture is with your creditors regarding all the things that the business might have. But in thinking, like Eric was saying, about if we wanted to prioritize what needs to be paid, and of course, just as Eric said, this is just kind of a general sort of advice, and it's not necessarily going to apply to everybody because everybody's going to be in a different circumstance. We need to talk to you about all this stuff to understand. I mean, if your landlord's getting ready to seize the property tomorrow and he's going to take your stuff and sell it, I mean, we're going to do one thing.
This is general advice.
Yeah, general advice. So most of the things that you would owe if you're going to shut down a business, we can get rid of if we end up filing a bankruptcy. So the things that would take priority if you get any money from the business would be things that we can't get rid of. And probably number one on that list would be taxes, and not just any kind of tax, but employer withholding taxes and sales and use taxes. And we call those, and perhaps employee salaries.
Yeah, let's make that one, and the taxes one.
Okay. We call these taxes trust fund taxes because you were given the money, like for sales and use tax, you collected that from a client, and now you've got to pay it to the state. Just like you got money to pay withholding taxes, and you owe that to the state and the federal government. And trust fund taxes never go away. So if you come in to see us, we might be able to get rid of the penalties for you, which a lot of times are significant. But the underlying tax liability is not going away. We can't do anything about it.
Meaning in a Chapter 7 where it's a type bankruptcy, where you're in and out of bankruptcy in 4 months and you got a fresh start, that debt is non-dischargeable. That's what Jeff says. You can't get rid of it. But we have many clients who owe trust fund taxes, and we work on plans to pay it back over 3 to 5 years through Chapter 13. And there's no interest that goes on that, and no penalties. Penalties drop off, interest stops. So let's say you owe $10,000 in withholding taxes. If you work out a deal to pay that back over 5 years to the IRS, penalties continue, and interest continues. Okay, so what are your options? You call one of those tax relief services that you hear on the radio or television or on the internet. Okay, what's bad about them? First of all, they cost a lot of money. And secondly, they are only helping you with taxes. They have blinders on, and they have this formulatic resolution to taxes that works or doesn't work. The difference is when you speak to a bankruptcy attorney, we have more tools in our toolbox. And we not only can deal with taxes, income taxes, withholding taxes, trust fund taxes, real estate taxes, all sorts of taxes, as well as credit card bills, medical bills, utility bills, payday loans. That's what we're seeing a lot more.
All your debt, we can do
everything.
Normally something with.
Right. And that's
especially in Chapter 13. If we can't eliminate it by getting a discharge, we can pay it through the Chapter 13 trustee, like Eric was talking about, paying taxes that were not dischargeable.
Right. So people come in and see us. We evaluate whether you should, you want to close the business. That's your business judgment. And most people don't want to close it. So by the time they see us and they say they want to close it, it's the right business decision. So we talk about Chapter 7 versus Chapter 13. But the whole idea is the weight off the client's back, Jeff. How many people see you the second or third time and say, oh, the phone stopped ringing for the first time in years. Oh, I thought I was going to lose my car. I thought I was going to lose my house. I thought bankruptcy meant I would have to close my checking account. None of those things are true. You keep all the assets you wish to keep in a Chapter 13. Now, of course, you need to be able to afford your mortgage or afford the car loan to keep them. But no one takes things from you, right? In our Chapter 13 plans, you don't lose anything.
Absolutely right. And so generally, that's the tact that we take with most people. So people might want to, when they first come in, they might say they want to try to do something with a business, But as you talk to them more and more, you can see that the business has just been a losing proposition. They're losing money every month. And our advice then would be to shut down the business, kind of let it die, and let's file a bankruptcy to take care of you personally, anything that you might be liable for. And then they're going to get a fresh start.
Exactly. And there are jobs out there, and really that's often the client knows that's the correct answer. And look, we have the overview, the highlight of this whole thing. If you take a big yellow highlighter, is this advice is different today because you're self-employed in COVID. It's hard out there.
Mhm.
And it's not a judgment about you or your business. Bankruptcy is a tool to use for you and for your business.
Exactly. How many, I wonder, I mean, you do read about it in the paper. How many people started a restaurant in February of this year?
Yeah.
And they got all this money to fix up a place, and they started a restaurant in February. And then the middle of March, they found out they had to shut it down. And it's been a mess. So what did that person do wrong? Nothing. They didn't know this pandemic was coming. They didn't make some stupid decision. It's totally just circumstances dictated that things were not going to work out for them. And we see that even on forgetting about COVID, generally in a lot of business situations. If you are a good plumber or a good carpenter, you go out and do your work and people are happy with you, and you get a lot of people as clients, and you're thinking, wow, I've got all these clients. I really need some help. Maybe I should hire some other people to help me out. And so you do that, and you end up running a business. So what made you successful, and that's being a good carpenter, a good plumber, now makes absolutely no difference. It's your skill as a businessman or woman that is going to dictate what happens with that business. And we see a lot of people that they're good carpenters, but they're not good business people. They're not able to keep up with all the things they need to do to have the business continue and be profitable. And
their best carpenter isn't doing the carpentry,
right.
right? Their best carpenter is sitting behind an adding machine. They still have them pressing those buttons and seeing how, and yet the young kids are out there doing the work. And it's, so they come to see us. They say, you know what, Eric, I want to do what I used to do. I want to work for myself, but I have to get rid of this corporation. It has nothing left. And I owe the supplier, and I owe that a lot of suppliers credit. I owe Home Depot, I owe Lowe's, I owe Universal. I owe these people money. And they can. They let the corporation die. They file a type of bankruptcy, either 7 or 13, where we list every asset and every bill. And the bankruptcy code, Congress allows you a fresh start. And whether it's 3 or 4 months or 3 or 4 years, whether depending on the type of bankruptcy, but right after you file bankruptcy, for the most part, we can guide you how to start a new business and do what you do best.
Exactly. And again, the fact that you have a business that might have failed is not necessarily your fault. It may have been due to circumstances beyond your control, whatever they were. And so you feel the weight of the world's on your shoulders, that you're trying to carry this business forward and it's not working, it's bleeding money. What are you going to do? And we can help you with that. We can talk to you about closing the business down, how to do that, how to take care of the debts that remain so that you're not responsible for them, so that you can walk away from this thing and you think like there's no end in sight, but there is. There's a solution there that we can recommend and help you with.
That's right. And it really is a great weight off people's shoulders. And again, they kind of know. Most people hesitate to talk to a bankruptcy lawyer. It's not one of life's highlights, maybe even worse than the dentist, okay? But at the point that our clients realize that they need to speak to a bankruptcy attorney, they pretty much are looking for help, and we can give that to them. Remember, and we've talked about this, spoken about this during every episode, there's good reason to speak to a bankruptcy attorney early in the process. If you think that your credit card debt is too high, your suppliers, as we talked about, self-employed people, it's just too much for you, speak to us now. However, if someone is suing you and you've received a summons and complaint, you must speak to an attorney right away, because you will lose certain rights under New Jersey law if you do not respond to a summons and complaint in a timely manner. And responding to the complaint can include filing bankruptcy. And that may be you do not want to ignore a lawsuit against you. So if you've received a lawsuit recently, call us. The phone number will be scrolled right along the bottom right about now. Call us and at least talk to an attorney about the lawsuit so we can stop it. Jonathan Stone has a question for us.
Yes, Jonathan asks, can a trade person keep his or her tools, or will those tools be lost to creditors? It just depends on the quantity, I guess. I mean, if we do a Chapter 13 for someone, you can certainly keep their exemptions that we can apply to the tools. There's an exemption for things that you use in your trade, for example, tools that you use in your trade. And there's a miscellaneous exemption and so on. And even if you were over those numbers but still wanted to keep the tools, it would mean you'd have to pay a little bit back to unsecured creditors.
But they won't take the tools.
Yeah, but you could absolutely keep the tools. So not only tools, but other things that you might have aren't necessarily lost if we end up doing a bankruptcy for you.
In fact, Jeff, we really counsel clients, if they come in with enormous tools that are paid for, and that's their livelihood, then they may not be able to do one type of bankruptcy. They may be able to do another.
Mm-hmm.
But whichever bankruptcy you choose with our firm, you will keep your tools if that's your priority. If, on the other hand, you're moving into a one-bedroom apartment and you never want to fix another toilet the rest of your life, yeah, we can work out that you can get rid of the tools too. But Jonathan, thanks for the question. But yes, under our bankruptcy laws, we can devise a plan for you to keep furniture, jewelry, appliances, whatever you have. If you want to keep it, you will keep it.
Absolutely right. So, anything else, Eric?
Jeff, there's so much new legislation out there that with the new administration coming,
mm-hmm.
we've been reading about potential new bankruptcy laws, mm-hmm. potential new laws about student loans. It's important for consumers, for our clients who have so much going on, to rely on us and to call us, because we are keeping updated on this. Jeff, more than me, perhaps, belongs to several groups that send emails and updates, mm-hmm. and he's very good at sharing them with me. And it is so. I'm not sure exactly what we're going to speak about next Thursday, but it will be Thursday. Well, it will be Christmas Eve special, a Christmas Eve special edition, perhaps.
We might have to talk to our boss.
Might be a Christmas Eve special edition.
Yeah, there you go.
So we may be talking about changes in the law, what we expect for 2021, and how we can help you.
Yeah, we want to do that. As soon as we see that there are going to be changes and what the changes are, then we can talk about them. A lot of times, as you read the paper and you see that somebody just proposed some legislation in the United States Senate to do blah, 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 that could go up in smoke tomorrow.
True.
You know, you wait till the president signs a thing and then you can talk about it. So until next week at 2:00, take care, stay safe, and God bless.